All right. The title of the talk is "What Song Do the Sirens Sing? The U.S. Law of Torture in a Wider Context." In the second supplement to Kant's tract, Perpetual Peace, he notes roughly the following. If you are theorizing a law to tell states on how to deal with other states, it would be absurd to suppose that there's some secret article in such a law. But Kant hedges on this, and he suggests that he thinks there might actually be one secret rule, and it's the only one there could be, right? This is Kant, of course. The secret rule is, the maxims of philosophers about the conditions under which public peace is possible shall be consulted by those states armed for war. So here we are. I will confine my topic to uses of torture as a part of a strategy of self-defense by state agents in a violent struggle against a foreign enemy. I believe such situations provide the most compelling grounds for using torture and hence provide a crucial test for any advocate of stringent restrictions against such uses. Conversely, if the merits of stringent restrictions prevail in these situations, then it seems more likely that a case can be made to support them across the board. To be clear, there can be stringent restrictions, what I'm calling them, that fall short of a total ban on torture. Nonetheless, as I'm saying it, stringent restrictions would have prohibited all or nearly all of the uses of torture by U.S. agents that have recently come to light. My arguments here will not constitute a defense of stringent restrictions of torture, nor its absolute prohibition, since some of the needed premises for my argument will be at least tendentious assumptions. Rather, I mean to compare two sorts of arguments one might make to restrict the use of torture, and to suggest that one of them won't work while the other one might. If it did work, one might hope it would convince our leaders to listen to philosophers more carefully than they have of late. Recent history shows that even merely stringent restrictions on torture need to be argued for. Pause to reflect for a moment on what then White House counsel Alberto Gonzalez's memo disparaging the Geneva Conventions as inapplicable to the global war on terror, what this memo had to say. And this is a quote on your handout. The nature of the new war places a high premium on other factors, such as the ability to quickly obtain information from captured terrorists and their sponsors in order to avoid further atrocities against American civilians, and the need to try terrorists for war crimes, such as wantonly killing civilians. In my judgment, he says, this new paradigm renders obsolete Geneva's strict limitations on questioning of enemy prisoners and renders quaint some of its provisions requiring that captured enemy be afforded such things as commissary privileges, scrip, athletic uniforms, and scientific instruments. There is much to reflect on in this brief passage. From the text alone, one could put a charitable interpretation on Gonzalez's complaint. Some of the provisions of the Geneva Conventions do seem outdated. But since he wrote these words, we know a lot more about how the Bush administration has used the license granted by this and other memos. It's not the letter of the convention that rankled the administration, but rather its spirit. The spirit of the conventions aims to constrain the prosecution of war in numerous ways, including to provide protections for civilians and captured combatants now out of the fight. Thus, the spirit of the conventions conflicted substantially with some of the administration's ambitions and tactics for subduing al-Qaeda, the Taliban, and Iraq. We are now beginning to see the fallout of this conflict. I will sidestep some of the technical arguments that Gonzalez made that al-Qaeda and the Taliban fall outside of the protections of the Geneva Conventions. I want to discuss something much more general, the way that thoughts about evil figure in the reasoning we see in Gonzalez's memo and in arguments for or against upholding stringent restrictions on allowable means of combat. For it is not obvious, I think, why torture must be stringently restricted. One may fairly read Gonzalez here as suggesting that the Geneva Conventions are quaint in their presumption that parties to a war will act in a civilized manner, that they will refrain from attacking innocents, and that they will uphold restrictions that may jeopardize their ability to emerge victorious. Instead, one may safely presume one's enemies will fight without constraint. To observe such constraints unilaterally is to make oneself vulnerable to an otherwise preventable evil. And given that the existence of mass casualty weapons, one must calculate in the possibility that one's enemies will inflict extreme damage. Thus, a premium is placed on achieving the total disruption of their operations. As President Bush declared a few days after 9/11, we will rid the world of evildoers. Although thought about evils is uneliminable from a serious discussion of war, it can figure in such discussions in a variety of ways, and how we include it makes a great deal of difference to how we should conduct a war. After a few prefatory remarks, I will canvass some ways that thought about evil can figure in thought about the laws of war, and draw out some of the implications. My thinking on this topic is occasioned by and framed by a few observations on what might generally be called man's inhumanity to men, and as often as not to women. First, we don't debate torture's merits for no reason. Rather, a context of war makes the lure of torture palpable, due, usually, to a sense of the enemy's evils. For instance, the attack on innocent civilians in New York and on the airline passengers of the hijacked planes counts as an atrocity, as Gonzalez suggests, and those who perpetrated it appear to be willing to do more of the same or worse if they are able. Preventing such atrocities is a core function of the state, and those who commit or seek to commit atrocities put themselves in harm's way. To the extent that torture seems an efficacious means in pursuit of a just cause, and we know that there are serious doubts about that, but presumably there is some case for that sometimes, the question of its permissibility will recur, and as Sanford Levinson notes, it is implausible and trivializes our difficulties to suppose that torture never works. Quoting here, he says, if after all there were no genuine lure of the sirens, Ulysses would scarcely have needed to tie himself to the mast. Most of us do not engage in such elaborate procedures in order to avoid walking into a pit of rattlesnakes. But the sirens sang beautiful music, and it was perfectly understandable why someone might want to hear their songs more clearly. Unquote. Second prefatory remark. While few would deny that torture is dehumanizing, its dehumanizing effect does not usually start from scratch. That is, it seems that at least in modern tortures, meaning, say, since the end of trial by ordeal, torturers find it easier to torture those regarded as human inferiors. And as Kathleen's talk suggested earlier, this seems to go all the way back, but I'll stick with the modern era from what little I know about it. So it's easier to torture those regarded as human inferiors and harder to torture those who are their status equals. Perhaps this is largely because there are comparatively few occasions on which an agent can dominate physically one's status equal. But such occasions are not entirely lacking. For instance, police regularly have such opportunities. Though the weight of the U.S. justice system no doubt falls disproportionately on ethnic minorities and immigrants, the use of torture seems even more disproportionately directed at them. If this is right, and I asked Richard Leo if it was, and he said it sounded all right, this suggests that the tendency to think torture justifiable tracks an underlying chauvinism in which some people are regarded as less worthy of human respect than others. Hence, we should be on guard here against a serious ethical failing that is often quite obvious when we witness it in others. Third, and possibly as a consequence of the above two facts, the U.S.'s recent turn to torture appears to go way beyond what any prominent philosophers and theorists have been willing to argue could be justified. Although theorists have heatedly disagreed with one another about, say, whether an absolute exceptionalist prohibition is justified, virtually none of the academic theorists that I've heard of would give any license to the kind of use of torture that's been used. We have probably not seen in public a single case of torture that would meet the sorts of restrictions that current academic theorists would impose if they had the position to do it. So this last observation might prompt us to suppose that debates over the stringency of our restrictions on torture just don't matter very much, at least in practical terms. Both sides, the absolutes and the stringent restrictionists maybe, would equally reject current U.S. policy, and U.S. policy seems equally indifferent to both of their cases. But yet there is evidence that states in general are responsive to criticism of their uses of torture, if only in that they seek less obvious means of torture, as Doers pointed out here a minute ago. If that much is so, then perhaps a more persuasive bit of ethical guidance will also have an impact on action. To find this guidance, it is useful to think more systematically about how evils are involved in our reasoning about war. There are at least 6 kinds of entities, there are probably lots, but 6 I'll mention here, that we might judge as evil. These are individual people, groups of people, events, outcomes, situations, take that as a lump, actions, rules, practices, and or say mental states, say one's motive or intention or an idea or something like that. It will suffice for my purposes here to limit the discussion to evil individuals, events, and actions, focusing especially on the latter 2. In the above quote, Bush posited a goal of ridding the world not of evil doing, but of evil doers. His view, not uncommon or unwarranted, I think, is that there are some people who simply are evil by virtue of their bad characters, whose goals are often evil, whose acceptable goals are often pursued by wantonly evil means. It is not hard to provide examples. But it's also easy to spot the danger in setting the state on a course to eliminate evildoers because of their evil natures. Namely, that danger is that if the target is the doer and not the doing, one can easily become engaged in unnecessary battles against enemies more imagined than real, and at least some of whose enemies, some of our supposed enemies here, may be harmless and or innocent of any actual wrongdoing. But even if there are dangerous evil people who may take themselves or their countries to war against us, it is important to be realistic about evil in ways that run contrary to current common sense. It is rare, even among evil heads of state, to seek the destruction of others for its own sake. It is much more common for them to display callous disregard for many, to brutalize some of their subjects for instrumental reasons, and to attack a comparatively select few out of spite. Insofar as their ends are not themselves predominantly bad, it may in fact be possible to use leverage to induce evil heads of states to use more benign means to achieve their otherwise acceptable ends and to, say, defer their evil goals. Moreover, even if a people's leaders have distinctly evil goals, it is rare for them to be as widely and as ardently shared by their ordinary inhabitants. Hence, it may be possible to make common cause with those upon whom evil leaders rely, who may themselves be victims of our enemy. Lastly, it is also crucial to attend to one's own ambitions and goals and past actions when confronting the evil ends of another. Bad U.S. behavior certainly bears some responsibility for allowing Saddam Hussein and Osama bin Laden to assume positions of power, and U.S. conduct in the Middle East continues to provide a grounds of legitimate grievance to our enemies. In short, though the evil nature of an adversary may help provide some reasonable incentives for going to war against them, it may be possible to avert war by leveraging their own self-interest or that of their supporters. These possibilities and defects in the justice of one's own cause may often undercut claims that one has just cause for making war against them. Now, turning now from evil as a quality of individuals, I want to consider ways that evil outcomes and actions figure in our thoughts about the proper conduct of war. Although it is tempting to leave the door open to torture in case it might help us avoid manifestly evil outcomes at the hands of our enemies, I will argue against the use of consequentialism as a way to make such decisions. Consequentialism as a theory of ethics is unsuited to help us avoid the evils inherent in war. I propose to consider instead a different, sensible approach to ethics that is non-consequentialist, in that it can make sense of the idea of a bad kind of action. I will not go so far as to argue that actions that are of a bad kind can never be justified, but I will stop at 2 more foundational claims, and these are on the handout here. First, that it makes sense to talk about kinds of actions that have intrinsic ethical qualities independently of their further predicted consequences. And 2, that the goal and perhaps even the possibility of achieving and maintaining a just peace between potential enemies is aided by identifying and committing to forswear bad kinds of actions. I'll take consequentialism with respect to actions to be the doctrine that the value of an action is determined in prospect by its reasonably anticipated consequences, and those of the most beneficial, by that I mean the difference in value between its anticipated consequences and those of the most beneficial of the other actions that were open to the agent at the time. Add to this that in any situation one should take the action with the highest value, i.e. it's a maximizing theory of the right, always aim for the best good or the most good, and you'll get consequentialism as it is standardly understood. Because the ethical worth of an action is identical to with the comparative worth of its predictable consequences, consequentialism has little interest in categorical restrictions on actions because of their kind. For instance, the fact that an act counts as torture will be of no great significance. Although torturing X will be a predictably very bad thing for X, for her loved ones, and possibly also for the torturer himself, if torturing X is the only predictable way to prevent more numerous and grievous harms, and if there are no other costs, then torturing or refraining from torture depends upon the comparative value of its anticipated consequences and on nothing else. There is thus no point in taking account of kinds of actions here or attributing value to different kinds, except insofar as kinds provide epistemic help in predicting consequences. Now, consequentialism is an extremely attractive approach to ethics in that it apparently mirrors the instrumental structure of practical rationality. That is, the rationality of an action depends upon its efficacy for achieving its intended ends. Nonetheless, there are numerous criticisms of consequentialism, some of which are relevant here. And I'll go through a few of these. First, there is the problem of making good predictions. As we've noted here already, it's hard to know or guess accurately what benefits will come of torturing someone, or whether torture is likely to be a more effective interrogation method than its rivals. While some of the harmful effects of torture are quite easy to predict, one hard thing to assess is the effect that torturing one individual can have on, say, the activities of others. One's aim in a just war is to reach a just peace as quickly and harmlessly as is possible. When one's enemy recognizes that it may face torture if it surrenders, this might, say, bolster their will to fight or to resort to unscrupulous means of their own. Or it might not. In any case, these sorts of effects may be very hard to assess. A second noted problem is that maximizing consequentialism with respect to actions will require that one take whatever course of action has the best predicted outcome, no matter how small its advantage over its rivals. Thus, it's not clear why a consequentialist would limit uses of torture to just those cases where atrocity looms. If the predicted outcome of torturing a person is slightly better than the predicted outcome of refraining from it, then consequentialism would hold torturing is required. This is not the slippery slope argument that suggests that psychologically, once the prohibition is breached, there's no stopping. Rather, consequentialism gives agents no principled reason to avoid torture if torturing has the best predicted outcomes. Its justification will not be limited to extreme or atypical situations. Now, before addressing the obvious rebuttal to this objection, and the obvious rebuttal I'll get to in a second is rule consequentialism, as it's called, I want to spin out the difficulty I've just laid out here a little bit further. Here, we need to think again about the context of war, where we are considering the use of torture because we are confronted by an enemy who aims to do us harm and whom we aim to harm in response. Both parties, then, have reason to fear that their opponent will do grievous harm to them, if given the chance, So there is a high cost in failing to stop the enemy for both sides. Thus, even if both are committed ethical consequentialists, both are licensed to use some very harmful means against the other while still aiming for the best possible outcome. They're going to do this thing that's so bad to me, so I can do, if it's the best outcome, I can do anything almost as bad to them, right? It's kind of a war of to the bottom, race to the bottom. Add to this situation two facts mentioned already, that accurate predictions of the consequences are hard to come by, and that there is a natural tendency to demonize people who are ethnically, religiously, or socially different than oneself, especially when it seems they want to kill you. In such a context, even well-meaning consequentialists can be expected to commit atrocities against the other while still aiming all the while at the best state of affairs. Now, in light of such worries, the consequentialist has an obvious rebuttal, as I mentioned, namely, to point out that a consequentialist need not evaluate each possible act of torture piecemeal, but can rather evaluate a whole policy that would regulate the use of torture more generically. Suppose, then, that we could reasonably predict that things would go best overall if the use of torture were limited only to cases where it might avert a true atrocity. Probably can't make that policy, but suppose we could get the policy right. A consequentialist might then endorse this policy and endeavor to follow it whenever confronted with an occasion in which torture might be used to, say, improve outcomes, though only slightly. That's the goal. While there is something hopeful in such a solution, it requires that we think in a way that is inimical to the impulse to consequentialism and which requires conceptual resources that consequentialism rejects. In particular, it requires that we recognize acts of torture as in some way ethically distinctive, such that one must forego torturing even when it is apparent that doing so would produce the best results. And that's why you need the policy against it, right? It looks like it's best to do it here, but the policy says don't, so I stop. So why does torture come in for that specific restriction? The impetus to consequentialism is the view that everything is to be judged based upon its predictable consequences. If nonetheless we must follow a policy against torture when it seems torturing would be for the best, this suggests that some kinds of actions are to be evaluated not based strictly on their consequences, but based on their place in or connection to some pattern or practice. And this is, of course, quite reasonable, but it creates two large, I'll call them theoretical holes for the consequentialist to fill. First, she must find a way to calculate the value of upholding or violating the policy, as individuals must still make that decision. Right? Should I violate the policy now? It looks like it's okay. Maybe not. Who knows? How do you make that decision? Even more difficult, I think, she will need to determine why it is that some actions, but not others, are regulated by policy, discounting or ignoring their particular consequences. One might have thought that the point of being a consequentialist was to avoid assigning ethical weight to facts about actions other than their consequences. Now it seems required. I will push one step further, however. Suppose a rule consequentialist can craft a policy that's stringent enough to avoid routinizing torture while permitting it when it's needed to avoid atrocities. Even then, such a policy will fail to provide a conceptual basis that allows two warring parties to settle upon an arrangement for a just peace. For one thing, it's not clear that such a policy, say, could draw a principled distinction between torturing one's sworn enemy and torturing his non-combatant family. One can imagine a number of scenarios in which attacking the family might be the better means, consequentially speaking, right? The guy gives over quicker, maybe. Moreover, consequentialism can't make sense of the idea that in torturing an innocent person, whether by mistake or by design, one has committed a wrong against that person and gives rise to a redressable grievance, rather than simply a decrease in overall well-being. For that reason, it also fails to support a case for rectifying past wrongs as a matter of justice, and a grounds for reconciliation and peace. Because consequentialism is inherently a future-oriented theory, it tends to undercut the sort of rectifications or one might wish to secure as part of making peace with one's enemy. These difficulties should prompt us to look for a different ethical approach to torture and other means of war. A potentially fruitful alternative approach attends carefully to what we might describe as the ethical qualities inherent in particular kinds of action. This approach may be described as deontological in character, but it has more affinity for both the Judeo-Christian tradition and for a Greek sort of ethics of character than it does for Kant, at least as Kant's earlier works would seem to suggest. This approach takes it that there are some ethically significant kinds of actions, and that many actions may be bad or good because they are of a certain kind. Those who think in these terms are likely to count murder, betrayal, and lying as bad kinds, benevolence, fidelity, and justice as good kinds. What follows from this is maybe somewhat obscure, since it will depend on how bad a kind is, whether it's absolutely prohibited or usually prohibited. For instance, the prohibition on murder binds much more stringently than the prohibition on lying. Or, if instead of stringency, we might think in terms of justification and excuse. So, for instance, there may be many more grounds that could justify or excuse a lie than a murder. Indeed, there might in fact be no grounds that could justify murder, and its conditions for excuse might be much more constrained. There are no doubt many difficulties to confront in determining which are the good and bad kinds of acts, and I'm not going to be in a position to give you any account of that here. However, here's one example. Following Anscombe, we might accept that murder is the deliberate killing of the innocent, whether for its own sake or as a means to some end. The badness of this kind of act and the prohibition on it are such that there are few, if any, justifications for it. So you couldn't say murder one person in order to prevent the murder of 5 others. That would not justify it. This approach to ethics has proven hard for many to swallow. It helps if one can cite and believe in divine backing for these judgments, but that's not one of my options. For my part, I want to consider briefly its interest with respect to considerations that arise in just war theory, which is concerned with ends such as preventing armed conflict, limiting its scope and duration. Wars end in several different ways, though through the annihilation of one party or its enslavement or submission, through either wearing out or just simply like a standoff, or, preferably, through an agreement to a mutually acceptable terms of peace. The moral costs of achieving the first outcome should render it unacceptable. The second outcome is unstable. So, if war can't be avoided to start with, there is moral reason to seek the third sort of resolution. But one should expect there to be significant difficulties in reaching such peace agreements, due to a justified lack of trust between the parties, since neither side is supposed to retain the ability to impose its will on the other by force. Moreover, there may be claims of past injustice that require resolution. And there's not going to be any basis for negotiation here that's a priori, that starts from someplace that the parties can both agree to prior to coming to the peace table. But if the view brooded in this talk is correct, hostile opponents would still have the ability to evaluate the quality of the other's past public actions. This then can provide at least some starting points for achieving trust based on assessments of the other party's character. It can also aid in reconciliation by yielding an objective assessment of each party's past wrongdoings. And because the qualities of actions in war are largely apparent not only to the leaders of each party, but also to the citizenry, according to, say, whether non-combatants have been targeted or whether captured soldiers have been tortured, the two groups of citizens can have their say in whether to continue or terminate hostilities. A demonstrated unwillingness to engage in unjust action even in war can signal an enemy that it can likely find livable terms of peace. But this depends on the possibility that hostile parties can and will assess the actions of the other accurately. I'm out of time here, but I'll just say briefly, I think consequentialism, if you're using this as their theory, or have been using this, will undercut this possibility. right? If what you were doing was thought to be for the best because you predicted that it would have the best consequences, how would the other side know that that's why you were doing it, because you were a consequentialist and you committed atrocities because you were afraid of greater atrocities if you didn't? So the idea here is that if we can identify particular types of acts as bad or good, stick to avoiding the bad ones, then it will be easy enough for the other side to see that you have withheld your performance of very bad acts, and they can have a reason to trust you. You can also use this as a way of deciding when something bad has happened and reconcile at the end by paying recompense. All right, I'll stop there.
Jeff McMahon.
No, Q&A.
Questions.
Oh, 10 minutes of Q&A, or whatever.
Yeah, Scott, I really liked what you said about evil and demonizing, and in studying religious violence in India, you certainly see those same features in ethnic or religious violence more generally. That is the imputation to the other of dehumanized characteristics, but also at the same time of threatening bad characteristics. But I think the remedy you propose, the focus on acts, is in that way incomplete, because what you saw in that case was that the education these kids had was one that encouraged an imagination that was polarized and stigmatizing in that way. They learned that Hitler was a great hero and all kinds of stuff, and they never learned to see another as a real human being, so their moral imaginations were very stunted. And I think in general, we know that education can make a tremendous amount of difference in how you see formerly dehumanized groups, whether people with disabilities or people from other races and so on. So I guess in terms of philosophical theory, I'd like to push you in the direction of something that is richer, that includes an emphasis on the work of the moral imagination, let's say more in the spirit of Aristotle or Iris Murdoch, but something that is more in the, as it were, the virtue-producing tradition than just the act-focused tradition. Because I think without that, you really, in the end, you don't get on top of this problem.
I don't think that I've said anything to disagree with that or to make any moves in the direction of how we would work out which kinds of acts would matter. But I guess what I'm thinking here is that being able to imagine the goodness or badness, say, of these particular acts is important, as opposed to, and I'm not sure what the right alternative here is that you might want to push against me, but imagining their character or imagining their internal goodness or something like that. I'm just saying here, we would need an ethics that would figure out what counts as, say, an intrinsically bad act. That is one that you shouldn't do, and if you do it, this is a sign of bad character, right? And then when you see somebody in war refraining from taking advantage of the good that might come out of doing a bad kind of act, you have a sense, okay, here's somebody I can trust who will not disadvantage me unfairly.
See, what I want is an ethics that says certainly things about bad acts, but says that it's also quite important the quality of the imagination and the thoughts about the other from which these acts do or don't spring. And unless you get to that deeper level, I think you're always going to have the bad acts, no matter how many rules you've got.
I think I don't disagree with that. I think that the Indian situation, however, I'll just distinguish what I'm worried about from the Indian situation. There you have people who are co-inhabitants of the same place. So they come into contact with each other. They have many more opportunities for bad acts towards one another. I'm focused on warring states where that sort of contact is perhaps harder to, the imagination may be harder to cultivate, the necessity of it may be smaller, because once you've made peace, you don't really even have to deal with the other side if you don't want to. That's far enough for this. You want to call people?
Eric Posner. Okay, whatever. Sure.
Yeah, I wanted to ask you about your last claim that in order to bring a war to a swift, just conclusion, there has to be a way to establish trust, and it's helpful to have objective grounds. And I gather you're referring to the Geneva Conventions as objective grounds, although I wasn't sure whether you meant a legal document or more moral rules. But so I have two questions about this. One is this an empirical claim, Or does it depend on empirical facts? Because if it is, it seems to me that just looking at recent history, it doesn't seem particularly plausible. If you think, for example, about World War II, Germany committed all kinds of atrocities. It reconciled very well with many of its former enemies. So did the United States, so did Japan. Now, of course, Japan did not reconcile with China, and there are examples on your side as well, but it doesn't seem like a very strong pattern.
Right.
And then the second point, which goes to this question about whether you're making a claim about the Geneva Conventions or not, is that I think that is in part the theory of the Geneva Conventions. But the Bush administration's claim is that that's a theory that makes sense in your context of two warring states. And one could very well make that judgment that at some future point these states are going to have to get along with each other when the war is over. But then I think their claim is that that logic doesn't apply here when you have a conflict between a state and a non-state international organization. And in fact, the Geneva Conventions, as originally written, clearly excluded that type of conflict.
Right. The second one, I just missed it. You said that's between the U.S. and Al-Qaeda? Right. Okay. So the first one, we would have to define whether or not these are, in fact, cases that would say, okay, here's where you attained a swift and just peace. Germany will be hard because, it was not swift, and it perhaps was just only in the sense that, say, this was a country being led by an extremely bad person. But let's take Japan for the contrary case here. It was a fairly swift end to that war, but it certainly was not a just end to that war, and I think it would be hard to defend, and at least Anscombe, I will side with her, that the way that war ended was not a just end to that war, and so I would not want to see war. I would not want to advocate that policy of exterminating large quantities of people for the sake of achieving peace, right? Now, so if the issue is after the fact, do you have a reconciliation of the people? I suppose you do, in a sense, through sort of like subordinating them for some period of time, and then they get over it, and we become friends. But I suppose that there's something about that period of what happened after we had firebombed them and annihilated two of their cities, and Tokyo besides, that would explain, say, how we got to a point where there was reconciliation possible. With Al-Qaeda, right, I think that hearts and minds here are going to matter. We haven't actually gotten where we're going with that. So let me use that for the first point. If we're going to defeat them, it seems like we need to win over the hearts and minds of a lot of the people who are supporting them who aren't actually out on the battlefield. Yes, the Geneva Conventions don't apply to them, but I think that I'm not actually worried about following the Geneva Conventions per se. I'm worried about, say, whether or not, say, our torturing or other atrocities committed against people in the war on terror tend to turn more of the potential supporters for Al-Qaeda towards their side or ours. I think the evidence so far is that the way we're fighting Al-Qaeda turns them towards supporting Al-Qaeda rather than supporting us.
Okay, then if I can just ask your answer to the first question, it sounds like it's an empirical claim. What are examples of wars that ended justly and resulted in reconciliation, where you think that this plausibly resulted from the fact that both sides complied with the laws of war?
Yeah, that's a good question. I won't be able to give you a single example right here, but that's the thing that I need a thing to sort out.
I have a question. When you talk about,
I should say it's not because I don't think there are any. I just am not.
I guess I would want you to distinguish somehow between public rationale to go to a war and rallying points that are thought likely to win support and also to mobilize troops as a kind of rallying point, and actual intents or actual reasons, which may vary over time in the course of a war. So that is, I presume there's a political and public role that goes on, often not thought about or talked about much in just war theory, in the sense that, in particular, soldiers abhor an ideological vacuum. They want to know and be able to say easily what they're going for. Evil may play a role in that, versus what real arguments, justifications, compromise points. I take it in the run-up to this war, there was lots of discussion, and maybe a very small number agreed on WMDs, but it wasn't a large part of what was going on in the discussion. That was one. Maybe this is a rallying point. Maybe that's one we can hold on that we can make public. So there's a public and a private discussion, deliberative discussion about cause that goes on, and there's a public set of arguments, often with a point of view of mobilizing and motivating and winning approval and all that. And I wonder if I didn't hear your remarks addressing that. I don't mean to come into the side, but I wondered what you were saying.
So I'm not sure that I have anything useful to say about that.
Evil would play a very important part in my mind in the public mobilization and motivation discussion, and not clear that it's always what's going on in the reference.
Sure, yeah. But I mean, I guess, the last sentence of the paper, which I didn't read, is something like, the first rule of a just war theory is don't start the war if there's any good way to avoid it through any just, peaceable means, right? And so the first thing you have to do is try to avoid war if it can be done without giving up your cause or identity or something like that. Once you violate that one, then lots of other things are going to be hard to achieve. So if the enemy is not the cause and their evil deeds in some sense are not the cause of your going to war with them, you don't have a cause for going to war with them. And so whatever's going on in the back rooms it would be evidence of this being an unjust war. And everything else falls apart from there. Okay.
Our 10 minutes are up, so
my view is that it is really of the gravest importance that we should oppose the practice of torture as strenuously as we're able. Those of us who are academics, and in particular those of us who are philosophers, are probably going to make our contribution by means of argument rather than through other means of resistance. And if we're going to make our contribution in that way effectively, we've got to oppose the practice of torture for the right reasons. That is to say, our job as academics is to get the arguments right. And I'm here today to try to help with that. One feature of the public debate about torture that I find curious is that many people who say that they are absolutists about the morality of torture, that is, they claim that in principle nothing could ever justify torture, are nevertheless not absolutists about any other area of morality. I think it's a mistake to be an absolutist about any area of morality. I think it's a mistake to be an absolutist about killing. I think it's a mistake to be an absolutist even about the intentional killing of the innocent. I think it's a mistake to be an absolutist about war. That is to say, I think it's a mistake to be a pacifist. Now, I think there are a lot of reasons why moral absolutism is untenable. In some cases, the main reason has to do with risk or uncertainty. So, for example, if you claim that it's absolutely prohibited to kill people, what are you going to say about cases involving a risk of killing people? If you're an absolutist about the intentional killing of the innocent, that is, if you think that it's absolutely prohibited intentionally to kill the innocent, what are you going to say about cases in which it's uncertain whether somebody is innocent or non-innocent? Now, I don't think that these problems, in the form in which I've given them, are particularly difficult in the case of torture. After all, it's rather difficult to risk torturing somebody, if you think about it. I mean, you can risk being the occasion of somebody's being tortured or whatever. But there is a general objection to moral absolutism that does apply to torture. This is that absolute prohibitions, just like deontological constraints, as Scott says, apply to act types, that you have to specify a particular type of action that is subject to the absolute prohibition. So, for example, relevant act types might be killing, or participating in war, or torturing. But that then makes it very important, indeed necessary, to have a sharp distinction between, for example, killing and letting die, or between war and lesser forms of conflict, and between torturing and lesser forms of harming people. So here's the problem in the case of torture. Torture is at one end of a spectrum of acts that involve the intentional infliction of harm. The absolutist, therefore, has to set a threshold along this spectrum, a threshold beyond which an act counts as torture, but beneath which it doesn't, and then claim that while it's possible in principle to justify the intentional infliction of harms below the threshold, it's not possible in principle to justify the intentional infliction of harms above the threshold. And I think this is just untenable when the difference between an act just below the threshold and an act just above the threshold is insignificant. This is just an incremental increase in the degree of harm that's caused. Another curious feature about the public debate about the morality of torture is that those who say they're absolutist about torture never, to my knowledge, distinguish between the torture of the innocent and the torture of the non-innocent. And to my knowledge, they don't limit the absolute prohibition to the torture of the innocent. But when moral theorists are concerned with other matters, so for example, the morality of killing, they do think it's important to distinguish between the killing of the innocent and the killing of the non-innocent. In fact, most of us believe not only that the killing of the non-innocent can be permissible, but that there are cases in which the killing of the non-innocent can be morally required. For example, when it's necessary to kill a potential murderer in order to prevent him from murdering his innocent victim. And this brings me back to the point that David made yesterday about reciprocity. I would express it rather differently, but it's a point with which I want to register agreement. David's argument yesterday presupposed that there can be a moral difference between an act done by a culpable wrongdoer to an innocent person and the very same act done by an innocent person to a culpable wrongdoer. So, for example, an act of killing is an act of murder when it's done by a culpable wrongdoer to an innocent person, but it can be an act of permissible self-defense when it's done by an innocent victim to a culpable wrongdoer. Suppose that as in the example I gave yesterday during the discussion, suppose a man is about to murder an innocent child, and the only way one can prevent the murder is to kill the man. Take that as a case of possibility of third-party defense of the innocent. Now I'm going to now do something that's probably rather impolite, which is that I'm going to say something that's critical of some of the remarks that were made yesterday in the very moving speech by Justice Sachs. I want to ask, in this case, a case of potential defense of the innocent, what we would think of third parties who refused to intervene to kill the man in defense of the child, and who, by way of explanation, said something like this: "We're not like that. Our core values condemn killing, and we're not going to reduce ourselves to the level of the murderer by engaging in killing ourselves." I think that would be a mistake. I just think that would be a mistake. And I think that David's argument explains the mistake, explains why that would be a mistake. Similar remarks apply to war. Pacifists have often been converted to pacifism by a horror of what goes on in war that's akin to our horror of torture. But there are a lot fewer pacifists than there are absolutist opponents of torture. And I think it's easy to see why. Suppose that in 1939, the French had said, the Germans invaded our country once already in World War I. And we know from that experience what war is like. We've had experience of war. And now they're getting ready to invade us again. But we're not going to descend to their level. We're not going to do to them what they did to us in 1914. We're not going to fight in war ever again. We're not going to kill soldiers ever again. Well, I think the reason why that sounds implausible, while what Justice Sachs said yesterday wasn't implausible, is that killing people in war, though horrible, can often and obviously serve to defend innocent people against wrongful harm by aggressors in a way that can, by and large at any rate, confine the harm that's done to the wrongdoers themselves. But torture rarely can do that. It can rarely be defensive, and as Professor Rajali pointed out really strikingly this morning, it can't do that without indiscriminately harming vastly more innocent people than non-innocent people. But what I want to do here is register agreement with what David said yesterday by mentioning a hypothetical case. And hypothetical cases are important because they help us to understand whether our principles are plausible or not. If one could prevent the torture of an innocent person only by torturing the potential torturer, I agree with David, it would be permissible to do that, and indeed it would be morally required to do that. If you accept that it could be permissible to torture a torturer, to prevent that torturer from torturing an innocent person, then you reject moral absolutism about torture. If you don't accept that, then I think what you're doing is you're rejecting justice in the distribution of inevitable harms at the level of principle. That is, you're implying that it's morally required to permit unjust acts to be done when you could prevent those unjust acts from being done in a way that would be proportionate and discriminate. So much for moral theory there. As I've noted, I think it's only very rarely that torture, even of the guilty, can serve a legitimate defensive purpose. And it's very, very hard to torture only the guilty. Next, let me note a point that Kim Shepley made yesterday in discussion. She's also made the same point in print, and Marcia made very much the same point in her remarks yesterday more than once. And this is that while the question of whether to engage in torture is one that individuals obviously do face, torture is nevertheless not something that individuals do on their own. That is, it's not a private activity, it's a political activity. And what that means to me is that the most important question here isn't one of individual morality, but is instead one of social or institutional morality. So the relevant questions here, the most important questions for us to address are these. What does morality say about the design and functioning of institutions relevant to the practice of torture? What does morality say about what the law of torture should be? What does morality say about what our policy of torture should be? Now, law and policy are human creations. A lot of people write as if morality were. I don't think that's right, but I'm not going to go into that. Clearly, everyone recognizes that law and policy are human creations and have to be designed with a view to the likely effects of their implementation and enforcement. Not just effects understood in terms of the harms that they may prevent or the harms that they may cause, but effects understood also in terms of respect for or violation of rights, including human rights. These are questions that we have to ask about our laws and policy. What are the effects likely to be? So suppose you think, as I do, that it would be morally required to torture the terrorist in a ticking bomb case. Whatever you think of ticking bomb cases, imagine one that's plausible or whatever. My view is it would be morally required to torture the terrorist in that case. That's a pretty uninteresting point to make, I think. All it's doing is registering a rejection of absolutism about torture. So what? I think we should reject absolutism about everything. There's very little significance to what we want to say about ticking bomb cases. But suppose you think that that's the right thing to say. The relevant question, the most important question is, ought the law to contain an exception to the general prohibition of torture for that kind of case? The way we address that question, I think, is to ask, among other things, but perhaps most importantly, what would the effects of having that sort of exception be? Well, notice that all the instances of torture that Justice Sachs cited yesterday afternoon, that is, instances in South Africa, Chile, Argentina, so on, were cases in which torture was used by despicable regimes against innocent people in an effort to prevent those innocent people from bringing justice and democracy to their own societies. They were instances of torture done for terrorist purposes, torture to crush, intimidate, terrorize, and destroy opponents of a regime. Now, I actually think that nothing could be more important in the debate about torture than to emphasize, and to emphasize repeatedly, that most of the instances of torture of which we're aware have been of that sort, clearly wrongful instances of torture. That's a way of saying that when torture has been practiced, it has been unjustified morally far, far, far more often than it has ever been justified. I'm perfectly willing myself to believe that there have been morally justifiable instances of torture. I can't cite any, don't know of any. Seems to me plausible to suppose there probably have been some. But I'm not sure that that really matters. There's complex explanation why torture is more often unjustified than it is justified. Partly it's because those who are pursuing unjust goals are much more likely to do something as awful as torture than those who are pursuing just goals. It's also important to note that the forms that torture takes in the hands of those who are pursuing unjust goals are in general likely to be much more horrible than the forms of torture that are used by those who are pursuing just goals. And I think it should be perfectly obvious that people sometimes do use torture in pursuit of goals that are just as people use terrorist means in pursuit of goals that are unjust. Doesn't make what they do right. What they do is wrong. But you can still use these wrongful means in pursuit of just aims. there's also this, and that is that most people, when they're doing awful things, tend to believe that they're doing the right thing. They tend to believe that they are nobly dirtying their hands in pursuit of just goals. So even the worst torturers in Argentina, nobody's mentioned Central America in the 70s and 80s, but that was really horrible. Even most of these people who are engaged in these horrible things probably think of themselves as upholding the just order and defending the rights of whoever they think they're defending, the rich and powerful or whatever it is. But they think they're doing the right thing. So whenever you have a law that permits something to people who are in the right, people who are just, and you can't have any way ex ante of telling people you're in the wrong and you're in the right, which is the situation we're in now internationally. Whatever the law permits to the just is going to be done by the unjust. Because of this and the other claims that I made earlier, I think that anything that makes it easier, makes it seem more legitimate for governments to use torture is almost certainly going to have quite terrible effects generally. And in particular, it's going to result in far more violations of rights, including human rights, than would otherwise occur. So any legal permission to use torture, however restricted it may be, would make it easier for governments quite generally to use torture, and would therefore, in my view, have terrible effects overall. And for this reason, I think that even though we can make up cases in which torture is morally justified, and even though there probably have been cases of morally justified torture, we nevertheless have to have a law that prohibits the practice of torture absolutely, with no exceptions. Now, even people who publicly defend the practice of torture might concede this claim in the case of international law. That is, there are very few people who would want to create a legal loophole for regimes like the former Ba'athist regime in Iraq to practice torture. Nevertheless, there are a number of people who argue that the U.S. is different and that we can safely have highly circumscribed highly circumscribed provisions for the legal use of torture without precipitating the widespread practice of torture by vicious and undemocratic regimes, which are going to use torture to the extent that they find it expedient, whatever we happen to do. But I think this is a delusion. I think the Bush administration has already shown that we can't be trusted to use torture only on those very rare occasions on which it would be morally justified. I think nobody, no country, can be trusted to use torture only on those occasions in which it could be morally justified. I don't think we can write a law that could come anywhere close to the practical effect of restricting torture to cases in which there would be a good moral case for its use. More importantly, we can't proceed with torture the way that we have with respect to problems like nuclear weapons. In the case of nuclear weapons, we have permitted their possession to ourselves and denied their possession to others by such means as security guarantees, economic rewards, and other measures designed to make abstention from possession of nuclear weapons more attractive than possession to potential possessors of nuclear weapons. You just can't do something like that with torture. We can't permit it to ourselves and deny it to others by means of bribes and security guarantees and so on. If we permit ourselves to use torture, we will thereby forfeit any ability that we might otherwise have to prevent its use by others. If we practice torture, then any efforts that we might make to persuade others not to use torture would be no more effective than, say, a proselytizing defense of vegetarianism by somebody complacently enjoying a steak. The hypocrisy is just too transparent. So I think our only hope of being able to impose legal and other constraints on the use of torture in the service of unjust ends by vicious and cruel regimes is to deny the option to ourselves as well, even in cases in which we think that it would be morally justifiable. I think that's even less than 30 minutes. I think I've set a record, but I'm finished.
First half was thoroughly convincing, and the second half almost there. And I want to raise a question about how to make it thoroughly convincing to the skeptic. For the first half of the second half, the argument seemed to be that the two reasons for a flat ban are first, that torture is imposed in a way that's more unjust than just, and second, that the torturers believe that they're doing the right thing. Those seem to be the two pieces. Think, for example, of four analogies. Imprisonment as such, life imprisonment, capital punishment, and making war. All four of those would stand condemned plausibly, and I think clearly for three, life imprisonment, capital punishment, and making war, by those two arguments. So those two arguments can't carry all of the burden, can they? Okay, and the second half of the second half seems to me to be more on track in the consequentialist analysis. And there you suggested for the United States in particular, and here you, I thought, weren't going as abstract as the two arguments just stated did. You said we can't cabin our own practices and there's hypocrisy involved. That's why the U.S. and the hypocrisy is actually damaging consequential. The U.S. has been flat down. Okay, I suggest that might be right, but it depends on some empirical imponderables that would have to be specified to make the argument go through. We need to know, for example, our inability to cabin. What does that mean in terms of quantities rather than qualitatively? How much injustice would be done by our torture and how much injustice prevented? In terms of hypocrisy, we need to investigate, wouldn't we, the empirical question, whether you're right in fact that our own, let's say, narrow exception would have damaging consequences for unjust regimes that otherwise would not be tortured. That's a question, yes? So I think we went in a very convincing and correct and actually beautifully done, if I may say, direction, which is we have to balance out the various effects. And there's a good rule consequentialist reason for the ban. I'm not clear that the arguments you gave actually defended that claim. We should have to be a very fine-grained defense, wouldn't it, rather than just made the consequentialist defense plausible.
Good. I think you're absolutely right about the second half of the second half. That is the last point you made. There's a limit to what one can do in 30 minutes, but you're right. The claims there were incomplete and not empirically defended. I don't have a whole lot more to say about that right now, so I probably shouldn't have said anything about the 30-minute limit because if I had 35, I still probably wouldn't have been able to say anything. Let me say something about what you said about the first half of the second half, about the idea that the argument there would support outlawing capital punishment and making war. I think that a precisely parallel and analogous argument to the one that I've given is, in fact, the best argument against capital punishment. Making war. The difference there is that we can outlaw torture without depriving the innocent of effective means of defending themselves in a general kind of way. We can't outlaw war for everyone without doing that. We can't say it's always impermissible to go to war, even in self-defense. I mean, always illegal to go to war, even in self-defense. A, it's totally impracticable, and B, it's unjust because it's legally prohibiting innocent victims from defending themselves against wrongful aggression. There's a parallel here with gun control in the case of torture and some other means of, possible means of defense. It's sometimes said that if we have gun control, what's going to happen? We take guns away from everybody pretty effectively. We can't do it totally. Some people are going to retain guns, and there are going to be occasions in which individuals have effectively been denied or deprived of their only effective means of self-defense against wrongful attack if we take guns away. That's a prominent argument in the anti-gun control literature. And no doubt that's right, but if we can effectively get rid of most guns, we're actually enhancing everyone's security probabilistically from an ex-ante point of view. In that case, I think people can't really complain if they happen to be the unlucky ones who get in a situation in which they've been deprived of possession of a gun and therefore lack effective means of self-defense. In that case, if we have an absolute ban on torture, there may well be some cases in which torture would be the only effective means of protecting innocent people, but overall, innocent people are going to be a lot better protected by the total ban.
Well, thank you for your talk. I agree with you that torture is bad, and I agree with you that academics should have a role in deciding this. But I have to say I fundamentally disagree with much of your analysis, which is not uncommon to a lot of the torture debate going on in this country. The problem with these kinds of arguments is that the focus of your analytical frame, in my opinion, is incorrect. And in the sense you highlighted at the beginning where you're talking about torture as act types. Now it's true, torture constitutes practices or acts, but to analyze the problem of torture and the fundamental reason for which it should be prohibited, you have to consider something else, which is the relationship that constitutes torture. And relationship, in other words, the problem that many people have is like we either look at the victims of torture, we look at the practices of torture, but the most important place to look is the perpetrators of torture. And in the torture relationship, the perpetrator is the state or a public authority. And so we need to focus our analysis first and foremost on the entity of the state or the power of a state and the laws regulating state power, to which, that's the reason why torture is such a strongly, universally prohibited practice in law. Because of the fact that, not because of the soft-hearted concern of the potential victims of torture, but of the democratic and serious concerns about the excesses of state power and tyranny. And so the prohibition of torture in its absoluteness is literally essential for the prohibition of tyrannical stateness. And so it's, when we're talking about torture, we must always keep in mind, I think, for the state as an entity and the relationship that enables torture. So and I just wanted to take another issue, sort of saying, well, we can't outlaw torture, war, we can't outlaw torture. War and torture are both kinds of relationships, but they're not the same relationship. One can have torture in the context of war, etc., but war is, in a sense, an entirely separate and different thing. The torture relationship is when a person is in custody, in custody and being purposely harmed by, somebody who's acting in authority for a public purpose. So if we were just thinking of the acts of torture, what distinguishes torture, quote unquote, from domestic violence? Nothing. If we're looking at the acts, we must concentrate on the relationship. And if we're looking at the difference between going to war and torturing a prisoner in the context of war, it's the difference between a torture chamber and a battlefield, or the world is a battlefield. And I'll just use the example where, for example, John Yoo has, in a sense, he's prolific in justifying torture, war, and everything else. But one of the things that he can't really understand why, for example, it's so problematic to torture people, because he says, if you can go to war and you can kill people, you can injure them. And if you can, excuse the killing of innocent civilians as collateral damage, then you can certainly excuse the torture of innocent people. In other words, the point, he sort of is rooting it all back to the necessity defense of war and torture then becoming crucial, but it's not very plausible. But so the point that I would just, in a sense, argue about is that we need, in our analysis of torture, regardless of where we think about different things, we need to put the perpetrator, i.e. the state or the public authority, at the center of our analysis.
Let me say something about that. The fact that torture as a political act is done with the authorization of the state is something that might contingently affect the morality of torture, but it's no basis for an absolute moral prohibition on torture. The idea that it's done by one agent rather than another is no basis for an absolute prohibition. If it were, then your argument would leave open the possibility that torture done by private individuals is permissible. It's okay. It's not. I can't torture anybody. Look, if I take you down in a dungeon here and I, hammer nails.
That's cruelty.
You cannot torture.
That's torture.
All right. Well, again, I think. Forgive me. You're making a distinction here in law rather than morality, and that's like saying that. It's only war if it's done by soldiers. If I get 100,000 people together and we go and attack some other country and take it over and so on, that can't be war because it's not a state. Well, okay, if you want to, use the labels in that way, that's fine with me. Okay, if I take you downstairs and in order to get you to reveal some information to me that I want, and I hammer nails under your fingernails and stub cigarettes out on your face and that kind of thing. If that's not torture, it's as good as torture morally. So what I wanted to say here about the state is that your position makes it sound like we could allow for individual killing in self-defense or individual killing in defense of other people because that's individuals acting, but we couldn't ever have a justifiable practice of war because then it would be the state that was killing, and that would concentrate all this power in the hands of the state. Now, some pacifists do actually make that argument. Do you find that plausible? That mass killing can be okay by individuals but not by states? I frankly don't see what the relevance of the agency is.
I think one point in answering Cass and distinguishing those other cases might be the secrecy of torture, that even if the law says torture had to be open, there would be lots of reasons the state would not acknowledge it. So in terms of cabining the practice, it's a secret practice, so it's harder to cabin than life imprisonment or capital punishment where there's an open process that gets there. My question was, what does it mean to outlaw torture in the law? There can be, we have laws where we flatly prohibit something, and then there can be a necessity defense that's So I take it you're saying there should be no necessity defense. I'm also wondering, does it mean that we fail to live up to the standards if we fail to prosecute people? Because there's prosecutorial discretion, there's presidential pardon power. So are we on the way to the slippery slope, regardless of what the law says, if we simply fail to prosecute when there's a violation?
These are difficult issues about which I don't have really firm views. If you think that, as I do, in principle it could be morally permissible to engage in torture, then you have to allow for the possibility that in some instance a person may be morally required to violate the law. Should there be a necessity defense? I don't think so. I think that if people are going to break a law, an absolute law against the practice of torture, they're going to have to make themselves martyrs for the sake of morality. It's an odd idea. But in a way that could help to ensure that people will violate the law against torture only when they are certain, so certain that this is what morality requires of them, that they are willing to accept serious costs and penalties for doing what they believe that morality requires. Now, we should then, I think, leave it open that if there ever are instances of morally justifiable torture, the courts could have the prerogative to exercise leniency in sentencing. But I don't think that defendants should be accorded a justification of necessity or defense of necessity.
Okay, thanks.
My paper is an attempt to answer Richard McAdams' last question, coincidentally enough. So let me identify three positions, it seems to me, that one can find in the academic literature. The first position is that torture should be banned under all circumstances. And this is justified both on the type of absolutist morality that Jeff has criticized, and on the basis of a rule consequentialist type of argument that Jeff made. The second position is that torture should be legal under limited conditions, and this has been defended by people who either implicitly or explicitly adopt a rule consequentialist style of argument. I'm not going to defend or criticize either of these positions. I'm going to focus on a third position, which hasn't really been discussed up until Richard's question. This is the position I call the outlaw and forgive position. And I think it's probably the most common position in the academic literature. The outlaw and forgive position is the position that there should be a legal prohibition on torture in all circumstances, but nonetheless, in those rare circumstances where torture is permissible, the person in question should go ahead and do it, and then be forgiven by the legal process. Now, I'll read one example. This is from Henry Shu's article, 1978 article, which people have been referring to a number of times. The article is a little peculiar because the vast bulk of it is an extended, eloquent critique of torture under all circumstances. But at the end, under the pressure of the ticking time bomb hypothetical, he says, well, what if in this imaginary case where finally comes up, what should happen? And he says, the torturer should be in roughly the same position as someone who commits civil disobedience. If the situation approximates those in the imaginary examples in which torture seems possible to justify, a judge can surely be expected to suspend the sentence. Okay. To the legal realists among us, that sounds like he's saying that, in fact, there should not be a flat legal prohibition on torture. It's just that there should be torture with exceptions, but the exception should be applied in an ex post discretionary basis by judges. Now, in the legal literature, this position is actually, I think, probably the most common position. And among other philosophers, one finds it from time to time. And I want to argue that it's not a supportable position, that one has to either choose between the absolute ban or legalization. That is, some kind of limited legalization. Now, other people have gone through much better than I can the basic moral arguments for and against torture, and I'm not going to repeat them here. All that I'll say is that, so if you agree with Jeff that this kind of absolutist position cannot be defended, then one gets into this realm of rule consequentialism. There are also these deontologists who make a kind of a catastrophe exception, but it seems to me that they're essentially making rule consequentialist arguments. And then the argument becomes entirely institutional and empirical. And I think if you're wondering why philosophers haven't had as much influence on the torture debate than they maybe should, is that philosophers, as philosophers, know more about these institutional and empirical issues than other people. And it may be that people in power, rather than looking to philosophers or ethicists, are looking to people with experience, security officials and so forth, and asking them, what happens? Do these practices help or hurt? And I think they should certainly consult psychologists and historians and others who have empirical knowledge. But the philosophical debate, as I think Jeff said initially, it's kind of simple, and I'm not sure that the government officials can learn much from them. Now, I want to make an argument that's very much parallel to Jeff's argument. Jeff said, if I understood correctly, that it's odd that there are people who are absolutists, that people tend not to be absolutists. That is to say, most people say that sometimes killing is justified. And that these same people, however, then turn out to be absolutists about torture. And it's unclear why one can be an absolutist about torture and not an absolutist about other bad acts. Torture is horrible. It's not clear that it's more horrible than killing a person. Probably sometimes it is and sometimes it isn't, depending on the nature of the torture. So that seems to be an inconsistency. And so he switches then to what seems like a rule consequentialist argument, that in fact, torture has these bad effects that laws permitting killing do not. What I want to argue is that it's just as hard to make this kind of rule consequentialist argument about torture as it is to make about police shootings. Killings, and I'm going to focus on police shootings in particular, which somebody brought up yesterday. So there are a lot of bad acts that the government engages in, that is, it authorizes its agents to engage in, including shooting of innocent people. The shooting of suspects, of criminal suspects who threaten innocent people. And as has been mentioned, there's no certainty about this. That is, all that's required is that police officers act in good faith. They don't have to be absolutely certain that if they don't act, an unjustified killing will occur. And the same thing, as Jeff pointed out, happens with respect to war, that war can be justified under certain circumstances. Most people don't think there's an absolute ban on war. So looking at this from an institutional perspective, or what I'm going to use the term second-order considerations. In other words, once we've put the absolutist moral argument off the table, what people in the literature typically do, sometimes self-consciously, sometimes not, is they make these second-order arguments. They say, even if from a moral perspective in a perfect world there are cases, or a world with perfect information, there are cases where torture might be justified. In fact, in the real world, where there's a lot of empirical uncertainty and institutions are imperfect, there should be a flat ban. And the puzzle here is why people don't make the same argument about other bad acts like police shootings. And the structure of the argument about torture is exactly the same as the argument that legal scholars have addressed about police shootings and other types of government violence. So the first type of argument is a rules and standards argument. So the rules and standards argument points out that when it's time to convert moral commitments into legal rules, one has all kinds of choices. One could have on the one extreme, a flat rule, a bright line rule against some practice, or one could have a standard. So it's very easy to say we could imagine a world in which police are told you may never shoot anybody under any circumstances. In fact, we could just not give the police guns. The world would not end if we did that. It's a conceivable world. And the justification for this would be, Well, when police are permitted to shoot people, sometimes they'll shoot people who are actually innocent or who are not going to harm other people. That's an error. And if we have a bright line rule, that type of error will never occur. Now, it's true there are also circumstances where police will fail to protect an innocent person, but you just have to balance the two, and it may be that a bright line rule is acceptable. It's basically your gun control argument. And what we need to know then is just the empirics, that is, what is actually going to happen under the bright line rule where there's a ban versus what we actually have, which is just this really vague standard that police just have to act in good faith. They have to behave reasonably. And it may be, and so one looks at the error costs and the decision costs and comes to some kind of conclusion. Now, in the torture debate, people just say, look, you know, the ticking time bomb hypothetical never happens. And the real circumstances in which torture might be permissible are so rare that if we have a flat rule, the error costs are very low. That is to say, it'll be very rare, perhaps never, that will fail to save innocent people. By contrast, if we had a good faith rule, the way we do in the case of police shootings, then inevitably police will make mistakes and end up torturing people who should not be tortured. Okay, and then that's just an empirical point, and that's a question. That's all the point I want to make. Unfortunately, with respect to torture, we're in this, we just don't know. I mean, I think probably the safest thing to say is that we just don't know whether it's effective, whether it has, whether people who are empowered to engage in torture are likely to make errors more often than police officers. There's a tremendous amount of ambiguity. And oddly, we don't really put much of a burden on those people who think that police officers should have the power to shoot people. That is, I doubt there are any empirical studies that show that, in fact, the consequential outcomes are better under a regime of police shooting than if there were a ban. Until you know, we have more information, it's very hard to understand why there should be a flat ban on torture, or at least why torture should be treated so differently from police shooting. A second type of rules versus standards argument, or second order argument, is the slippery slope argument. This argument has been made with a tremendous amount of confidence by people. Again, though, it's a complicated empirical argument. So one argument is that if torture were permitted, even in very narrow circumstances, it would spread and would be used by, let's say, American security agents in situations where it's not justified, and as Jeff mentioned, in other countries. There's also this argument that if torture were permitted, it would brutalize society in some kind of way that's usually unspecified. Same arguments can be made about police shootings, but are not made about police shootings. That is, the people who make these arguments about torture, it never seems to occur to them to focus on this other act about which one could say the same thing. If police are permitted to shoot people, then they'll start shooting people who are not a threat to anybody. If police shootings are allowed, society will be brutalized. One needs to explain what the mechanism is by which this process occurs and point to evidence. In the case of, let's give another example of capital punishment, which of course is much more controversial than police shooting, one could very well make the argument that it's a type of government activity that would brutalize and perhaps spread. But the truth is the opposite, of course, that capital punishment has been on the defensive for many years. And even when the Supreme Court started to permit capital punishment after a brief pause, there's no evidence that society became brutalized or that it spread. In fact, around the world, capital punishment is becoming rarer and rarer. And in fact, it is in the United States in terms of numbers of executions. Final point that people make is about symbolism. And here again, I'm referred to a number of arguments in the legal literature. I'm not sure whether these arguments are made in the philosophy literature. But for example, Oren Gross, a law professor, says that coercive interrogation is in tension with the symbolism of human dignity and inviolability of the human body, right? And a lot of people have argued that a ban on coercive interrogation, even if it's justified in narrow circumstances and moral grounds, would have a desirable educational function. Jeremy Waldron has argued that the ban on coercive interrogation is what he calls a legal archetype that, and I'm quoting him, expresses the spirit of a whole structured area of doctrine and does so vividly, effectively, publicly, establishing the significance of that area for the entire legal enterprise. And so there are these arguments, again, that a ban on coercive interrogation would have symbolic or educational value, and that, on rule consequentialist grounds, justifies a flat legal ban, even though, and this is, of course, the assumption, the underlying assumption, it may be morally permissible in narrow circumstances. Again, all of these arguments, when you apply them outside the area of torture, become weaker. There are, of course, lots of accepted government practices that are in tension with the symbolism of human dignity and the inviolability of the human body. Police shootings, again. Imprisonment is, for that matter. The argument that the ban on coercive interrogation has an educational function is actually parasitic on the moral argument that it should be banned under all circumstances. Because if it's true that it actually is justified in narrow circumstances morally, as Jeff, for example, says, then why wouldn't you want to educate people with respect to that fact? And then finally, Waldron's argument is a kind of a narrow instrumental point. It may be that certain legal doctrines are useful as heuristics, but you can change doctrines of the law, and one should do that when there are moral reasons to do so. One can take into account any cost there might be on the operation of the legal system, but that's hardly a decisive argument for a complete ban. Now, I think what's going on here, though, is that people who are bewitched by the ticking time bomb example, they want to maintain the legal outcome, but at the same time, these same people, they want to maintain the legal ban, but at the same time, these people who I'm talking about are honest enough, or they're persuaded enough by the ticking time bomb hypothetical that they actually want to allow security officials to use torture in that narrow situation. And so the attempt to try to cut this Gordian knot takes the form of the outlaw and forgive regime. And I was really anxious to see how you would respond to Richard's question. And you are not a defender of the outlaw and forgive regime, although you'll allow the justification to sort of affect the sentence, but you're not, unlike Henry Shue, willing to suspend the sentence. But as I said before, it seems to me that most people writing in this literature, certainly law professors, defend the outlaw and forgive regime. So again, what I think is going on in the outlaw and forgive regime is that people hate torture. They're bewitched by the ticking time bomb example, but they don't believe that these second-order arguments that I've gone through are strong, right? That these second-order sort of rule consequentialist arguments are strong. So this is the way they try to avoid the horns of the dilemma. Well, what is the outlaw and forgive regime? I mentioned Shue's example, but it takes other forms. So other people have said, for example, that what happens is we should have this flat ban on torture, but in the ticking time bomb hypothetical, the security agent nonetheless goes and does it. He gets charged by the prosecutor for committing a crime. And then a number of things could happen. It could be that the president pardons him. Or the governor, as the case might be. It could be that the prosecutor would exercise discretion and not go through with the trial. It could be that a trial occurs, but the necessity defense would then be applied. Or it could be that the jury would engage in nullification and simply refuse to convict. Or it could be, any number of things like that. There'd be some kind of popular reaction saying, yes, this person violated the law, but it was justified, and therefore the person should not be punished. And again, it's striking how many people have taken this view, and I think the view is this argument is extremely weak. But to give the defenders of this argument their due, what I think they're trying to do is sort of maintain the symbolic rejection of torture while permitting it to occur in those narrow, morally justifiable cases. That's what they're trying to accomplish. But I don't think they can accomplish that. Or at least if they can, the cost may well be higher than the benefits. So here's why. One is just this assumption that public officials are going to violate the law. That is to say, it's very odd to say to the public officials, it's morally justified for you to torture people under these circumstances, but don't do it. You know, don't do it, wink, wink. Don't do it. I mean, if you say to them, don't do it, then they're not going to do it. Or the most plausible expectation is that they're not going to do it. In other words, they're going to say, okay, you know, I think this might be justified, but my, you know, the people, my hierarchical superiors and the law itself have told me not to do it. Well, I'm not going to do it. They must have reasons. They must have reasons. And in fact, we've seen this. You know, the reason why the torture memo was written in the first place was that the CIA agents who were told to interrogate people knew it was against the law, or suspected it was against the law. They were not going to act in this sort of romantic, heroic way that the defenders of the outlaw and forgive regime seem to assume people will behave. They're not going to wait and torture a person only when there's a ticking time bomb. They want legal authorization, and if they get legal authorization, they'll do it, and if they don't get it, they won't do it. But really the point is that at a very abstract level, the way that we want governmental officials to act is in compliance with the law. And so if we think that there should be that there are morally permissible reasons to engage in torture, then it violates all of our normal rule of law assumptions to actually ban torture and then expect them to go ahead and do it if it's morally justified. It's also, you know, it would also seem to me hard to expect these officials who, even if there's a ticking time bomb, which might kill a lot of people, to put their livelihoods on the line to actually risk prison, because there's some possibility that the public will rise up and support them for what they did. I don't think that we have evidence that people normally act that way. So if you think of soldiers under much more extreme conditions are expected to comply with legal rules, not to violate them. Now this other argument is the necessity defense argument. And this has come up in Israel, where the Israeli Supreme Court, in the course of banning coercive interrogation, discussed the necessity defense. And they were asked by the Israeli Security Service to permit, to say that torture is justified when it's consistent with the necessity defense. And the court said, well, we're not going to say the necessity defense is never available, but we're not going to say in advance that torture could ever be permissible. But this is not really an answer to the question. Either the necessity defense applies or it does not. Now, if the necessity defense applies, then in fact we're not in an outlaw and forgive regime. It's legal. It's legal to torture if it's necessary. And if it doesn't apply, it's illegal. This idea, as some people have argued, that you can use the necessity defense to maintain the symbolic ban on torture while permitting it when it's necessary, is implausible. As Sandy Levinson remarked, reliance on the necessity defense would not avoid legitimizing coercive interrogation. It would avoid legitimizing coercive interrogation only when it's not necessary. Okay. Another thing we can do is look at other outlaw and forgive regimes in the world. There are some. They're unusual. One you might think of as just the long-standing legal bans on sodomy that have existed in state law. And as everybody knows, authorities tend not to enforce this rule. And so we've got this odd idea where we've got this odd situation where a practice is formally unlawful, but people engage in it anyway, because it's not enforced. Now that doesn't provide, there's nothing attractive about this regime, right? Most people would simply say those laws should be repealed. Some people might think that those laws are justified, but there's no particular reason to follow the structure of the outlaw and forgive argument with respect to torture, that it would be, that we want people to commit sodomy only when it's morally justified and not otherwise. And for that reason, it should be illegal. A better analogy, though, and a very interesting one, is euthanasia, where you really do have something similar to what one might describe this outlaw and forgive style torture regime. So euthanasia is illegal in the United States, but everybody understands that it's practiced. And an argument for why it should be illegal, but nonetheless practiced, is something like maintaining the symbolic condemnation of taking a person's life while permitting it in these morally justified ways. But the effect of making it illegal is, of course, we have absolutely no idea what's going on. That is, we don't know whether actual euthanasia practice is morally justifiable or not, because the people who engage it don't want to admit that they're doing it in case that some prosecutor somewhere decides to start enforcing it. There's an even better example from the Netherlands where adult euthanasia is legal, but infant euthanasia is illegal. Infant euthanasia is nonetheless practiced, or was. And the doctors who practiced it were afraid they'd be prosecuted, so they actually told the prosecutors, they came to an agreement with the prosecutors under which they would report every time they engaged in infant euthanasia, and in return the prosecutors would promise not to prosecute them. And this promise not to prosecute was conditional on the reporting. But eventually the doctors just said, forget it, we're not going to do this. It's too risky. We're doctors. If we do this and some prosecutor decides to prosecute us and we're convicted, we'll go to jail, we'll lose our license. So either you have to legalize it, in which case we'll do it, or you have to ban it, in which case you won't do it. So it seems we won't do it. So it seems to me that the outlaw and forgive regime just is not stable. Now, that might raise the question why it exists at all, and I think there's a political reason, not a moral reason, why these regimes exist from time to time. The political reason is that the legislature, for whatever reason, its constituents believe that the practice in question should be banned under all circumstances. And the prosecutors and judges and maybe jurors in particular situations disagree. And so there's this kind of disconnect between what the legislative judgment and the judgment of prosecutors and others. But that may be why these regimes come into existence in the first place, but it's not a defense of the regime. That is to say, all of the rule of law reasons we have for wanting to publicize what behavior is permissible and what behavior is prohibited applies as much to torture as it applies to euthanasia or any other practice. So I want to conclude with just to emphasize that my argument here is very limited. It's simply about the outlaw and forgive regime. My argument is that it's not justifiable in the context of torture, and that people should either, on moral grounds, adopt the flat ban view or the view that torture should be legal under the narrow conditions where it's morally permissible. So I'd be happy to take that.
Actually, I'd like to start by asking a question. I think the general claim that, any time you've got a complete ban in the law, you can think of cases where it would be appropriate to do the thing banned. It's not specific to torture, is it? There's a complete ban on parking in the traffic lanes on Michigan Avenue downtown, but we can think of situations in which it might be appropriate to do that. Doesn't the argument apply to all complete bans throughout the codes of any regime, not just to torture?
Well, prosecutorial discretion is very common. And the usual explanation for prosecutorial discretion is that they're limited resources, and so that the police should focus on the most serious violations of the law. But beyond that, certainly, morally there may be many reasons to violate the law, but in terms of what I'm interested in is in terms of designing a legal regime. So we should tell our government, this is what the rules for torture should be. It seems to me that we have the choice of if we want the security agents to act in the morally permissible way, my only claim is that the rules should specify what the ways are. Now, prosecutorial discretion could come in later on, but I think the usual view on prosecutorial discretion is it's not how we want things to work. It's a regrettable consequence of the way that our government is organized. But at the extreme, we could just say to prosecutors, okay, you look around, and if you don't like something, prosecute, and if you do like it, don't prosecute it. And that's the logical extreme of the alternative view.
One of the central questions that you raise in the paper is why torture should be treated differently from police killing, pressing the analogy there. And I think that police killing has only one of the risks that legalizing some forms of torture runs. And that is the risk, when we allow police killings, we don't have the flat ban on police killings, we're running a risk that our police will engage in killing promiscuously. And there is, I think, a clear parallel in the case of torture there that other people like David Luban have emphasized, that if you have institutionalized torture, people aren't going to stop at the limits. But the other risk of torture, I think, isn't present in the case of police killings. And the other risk is that other people, and in particular the potential victims, will do the same to you. And the potential victims of police shootings, that is, criminal suspects, can't say, you know, if you allow police shootings, we're going to do police shootings as well. I mean, criminals can't do police shootings. So there's not the same kind of risk of spread in the case of police shootings as there is in the case of torture, where, I mean, there's no analog in the case of police shootings to the idea that if we engage in torture, Al-Qaeda, people who capture our soldiers, are going to do it too, but possibly if we hold a line against torture, other people will respect that as well, if only out of a general sense of that it's in everyone's interest just not to do this.
Right, but there again, you're making the same move that other people do, that you're departing from your first order moral argument here, which is that under narrow circumstances it is permissible. So to draw and this actually will go back to one of the points you made in your paper, and I think Cass was getting at this in his question. So we might say to the world, we don't want the rest of the world to torture. But that's, of course, if we come to the conclusion that it's wrong under all circumstances. If we think that it's wrong except in the ticking time bomb hypothesis, we should be happy if the rest of the world tortures only in the ticking time bomb hypothesis. And the problem with the dictators who engage in torture is that that's not the case in which they're engaging in torture. So the police shootings analogy to your argument would be, we shouldn't engage in police shootings, because if we do, dictators in other countries will order their security services to assassinate political opponents. We say, wait a second, we don't think that police shootings should be used to assassinate political opponents. We think police shootings should be used to protect innocent people. And that's the practice that should spread. In the case of torture, to the extent that there are moral grounds for torture in narrow circumstances, if that view is right, we should want other governments to engage in it as well. We wouldn't want them not to engage in it, and there'd be no reason for the U.S. to have some special privilege to engage in a practice that other countries are not allowed to engage in.
You characterize this as outlaw and forgive. I have a lot of difficulty seeing that, frankly. I mean, clearly it's a decision to outlaw. Your attack is on the architecture of the law, because the law, as it's evolved in Anglo-American society, has evolved a series of escape hatches. You're attacking the escape hatches. Of course, they're not there just for torture. They're there across the board. You know, prosecutorial discretion, jury nullification, the pardon power, the judge's discretion. All those things are there. There's a long history of them being applied in difficult or closed cases where popular opinion in particular is going to run against the exercise of that power. I frankly don't understand the structural argument. It also strikes me that the major point you make here directly contradicts your thesis. I mean, you say that the CIA agent is not going to use these techniques if they're illegal. And then you point to the OLC memoranda as the basis on which they act. But that OLC memorandum, or a series of them, did not change the law. These things are still illegal. I think that your co-author, Jack Goldsmith, said it just right when he said this was a non-prosecute agreement. So essentially, it's the same thing. It's a decision from the prosecutorial authority that we're not going to go after you. Because I think, frankly, we have very few people in this country who buy the idea that these techniques are lawful.
I think to answer your second question first, I think within the institutional context, what the CIA agents were worried about was simply whether they would be prosecuted or not. And there was precedent for CIA agents being prosecuted for engaging in unlawful conduct. So they were asked to do things which seemed, according to the CIA General Counsel, to be unlawful. So the CIA said to the administration, look, these guys are not going to do it unless you give us cover, right? Now, it seems to me it doesn't really matter whether one thinks that from the perspective of the CIA agents, whether the torture memo was a legitimate interpretation or not a legitimate interpretation. As a practical matter, they understood that if the Justice Department committed itself to this type of interpretation, it was highly unlikely that they would be prosecuted. On your first question, I'm not criticizing the practice of prosecutorial discretion or jury nullification or judges suspending sentences or anything like that. This is just a regular part of American law, but it's a little puzzling then, because I mean, if you just think of this as okay, well then we should all say, well, in fact, sorry, absolutists. As a matter of fact, in American law and everywhere else, from a legal realist perspective, torture is lawful under narrow circumstances, when it's necessary, or when a judge, in those circumstances where you can predict that a judge is going to suspend a sentence. Well, I suspect you think of law in a more formalistic way than we post-legalists.
I mean, because these same exceptions will be used.
Killing is lawful if it's self-defense or if it's necessary. And then it's, you can call it murder, you could call it justified murder, you could say it's not murder because it was justified. And the word torture, as I think other people pointed out, has a bit of ambiguity because in some ways it expresses the judgment, but it can also be defined narrowly to mean an activity that could be justified or not. And I think the structure is exactly the same. But in the case of killings, we say to police officers, go ahead and do it. If it's in good faith. It's also the case that they can fall back on these other defenses if they want to. We could say, we could say that we're already implicitly saying to the CIA, go ahead, it's lawful if it's necessary. Or we could say that the CIA agents, like police officers, deserve more of a kind of an ex ante rearticulation of this ex post defense so that they have more guidance over what they should do under these unusual circumstances. But in either case, it's sort of odd to think of this as expressing a symbolic rejection of brutality or torture, which is the basis of the outlaw and forgive argument.
There's one argument that I didn't quite see represented in your taxonomy that I think might help distinguish the police killing example at least. And it's an argument mostly in moral philosophy and not in law, although this is the one philosophy panel. It's the torture philosophy panel, excuse me. And there are some legal implications of it, which is that our concern with torture focuses at least as much on its effect on the torturer as on the society at large or the victim. And I think the best way I can describe it is one of those wacky examples Frances Cant is so famous for. It's the question she asked in another context, which was about punishment, right? So she said, what if the justifiable punishment for a rapist was that he be raped? The problem with that is that no human being should have to carry out that punishment. What it would do to the person who did it would be the problem. So if we had, she said, a raping boulder, well then we would be comfortable saying, okay, we'll have this appropriate kind of, I remember this vividly because I was sitting next to a non-native speaker of English who turned to me and said, excuse me please, but what is boulder? They said, a boulder is a large rock, giving him about as far as he was. But so, anyway, so the argument is the effect on the soul of the torture. And here's the legal situation that I think this comes up in, which is not a area I'm expert at. It's the categorical prohibition for physicians to engage in certain things, euthanasia being one of them, participation in torture being, or in a coercive interrogation being another, right? Because the idea is that this is so inconsistent with what it is to be a physician, and so corrupting of the physician, him or herself, that it's got to be outlawed.
Well, I don't understand how that you distinguish that from the police shooting example. I would think that shooting and killing a person could very well be worse for the police officer than at least some types of torture.
That very few of us are Lawrence of Arabia, who answers in the film of that name.
you know, when he says, I killed people when I was really upset, and the general says,
No,
I
I think
understand.
that's wrong. I think police
What he says
officers
is,
are
I
often
enjoyed it.
Yeah, no, but I think police officers are frequently traumatized, and soldiers also are traumatized from killing people. I think it's a cost. I think it's a relevant. It's certainly a relevant consideration, and I could easily agree with somebody who, on rule consequentialist grounds, taking into account this particular problem, would ban torture. But it doesn't seem to me that this would help on the outlaw and forgive side. That is to say, in that particular distinction between torture and killing is not relevant to the defense of the outlaw and forgive regime, which is what I'm focusing on.
I'm afraid we're out of time, but we continue to talk.